What is a standby guardian, and do I need one, especially now? Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and estate planning attorney in New York. Today I'd like to speak about standby guardianship. If you're a parent or a legal guardian of a minor child, and that's anyone under the age of 18, and you're worried that you may not be able to care for your child in the future, then you should name someone as the child's standby guardian. A standby guardian is someone that you name who can take over caring for your child if you're unable to do so. And there are a number of reasons that you may think of for why you would want to name a standby guardian. So you could be leaving the state, you could be debilitated, you could be incarcerated or incapacitated, and there's some important questions about when and how to name a standby guardian. So first, what's a standby guardian? In New York, a standby guardian is someone who has temporary authority to care for someone else's minor child. The standby guardian would eventually need to go to court, and that would be the family court in the county in which the child lives, and formally ask to be appointed as the child's guardian. But the standby guardian is an interim solution prior to getting to court. And then ultimately, the court would decide what's in the best interest of the child. But naming a standby guardian is an important way to ensure that someone can provide immediate care for young children. When should this person be named? When should you take this step in advance? Well, several situations in which a parent or legal guardian may want to name someone as the standby guardian. So, in New York, a standby guardian can be named if a parent is facing a possible administrative separation. And administrative separation means the parent or even the legal guardian has been arrested or detained, incarcerated, removed, or departed, or otherwise received an official government notice regarding their immigration enforcement, which would indicate that there's going to be interruption in the parent's ability to care for their children. So an administrative separation is a new category that was added to New York standby guardianship law in July 2018. And that was added specifically to allow immigrant parents at risk of being detained or deported to plan in advance for the care of their children. So another reason, and the reason that it might come up right now of why a standby guardian can be named, really would be incapacity or debilitation. So incapacity means that the parent or legal guardian has a mental impairment that would result in their inability to understand the nature and consequences of decisions regarding the care of their children. Right? So that's an incapacity, a regular incapacity that I've spoken about before. Debilitation would be appropriate at this time. It means if a parent or guardian is unable to care for their children due to a fatal illness or a physically debilitating condition. And if you're a parent facing one of these situations, you should consider naming a standby guardian. And if you have to discuss this situation or plan in advance, please go to callfrankbruno.com and I'll further explain for you. Thank you very much.